Normally, when one joint tenant dies, the right of survivorship means that his or her interest in the property automatically vests in the surviving joint tenant. But what happens if the surviving joint tenant killed the deceased joint tenant? The Oklahoma Supreme Court considered this grave issue in Duncan v. Vassaur. Edgar Vassaur Jr. owned commercial real estate in Okmulgee, Oklahoma. When he married his wife Betty, he added her name to the deed as a joint tenant with right of survivorship. 2 years later, Betty killed Edgar and the state of Oklahoma charged her with first-degree manslaughter. Betty then transferred the property to her father, William Duncan. Duncan sued Edgar's estate to quiet the property's title, but his petition didn't mention whether he gave valuable consideration for the property or knew about Betty's crime. Edgar Vassaur Sr., the victim's father and estate administrator, claimed half ownership of the property for the estate. He also requested 2 liens against Duncan's half of the property, one to recover half the amount paid out of the victim's life insurance policy to satisfy a mortgage, and the other to recover half the costs that the estate paid to satisfy a loan for improvements to the property. In addition, Vassaur claimed that the estate was entitled to half of the rent that Duncan had collected from a commercial tenant on the property. The trial court awarded judgment on the pleadings in Duncan's favor. The Court of Appeals reversed, and Duncan appealed to the Oklahoma Supreme Court.